Welcome to day 2 of the SAIS Europe Alumni Weekend, the 65th anniversary of the Bologna Center and the first virtual weekend in our history. In case you weren't present yesterday, I'm Michael Plummer of the Bologna Center class of 1982, and I've had the honor of serving SAIS Europe as its director over the past 6 years. I greatly look forward to this occasion every year, and I'm very happy that despite limitations in our movement, we're able to get together in this virtual space anyway. I hope you and your families are safe and healthy. We have an impressive number of alumni in attendance this year. As of early this morning, we had 592. All countries, all continents of the world are represented, and 53 countries. So we're going out on a very wide reach. Though we cannot see each other right now, later on this evening, we'll have a spritz reception followed by separate class reunions, during which we will be able to see each other virtually. Thank you all for joining us here, for being part of this community and contributing to our many efforts in the myriad ways that you do. I'm always humbled by the great generosity and by the resilience of our Bolognese community. Through our efforts as alumni, we are ensuring that SAIS Europe will continue to flourish and serve generations of students to come. And now, as is our wont at SAIS, it's time for a substantive discussion with my faculty colleagues around a hot topic, human rights and migration, which in the current context of COVID-19 is even more relevant this year as a key policy issue worldwide. Our panelists bring great firepower to the debate and, of course, all teach here at SAIS Europe. I'm honored to pass the floor to Professor Justin Frosini, Adjunct Professor of International Law and Director of our Center for Constitutional Studies and Democratic Development. Justin, the floor is yours.
Thank you very much, Mike, and hello, everyone. It really is a delight to be chairing this panel as part of the Alumni Weekend celebrating the 65th anniversary of SAIS Europe, or rather the Bologna Center, as we like to call it. And to be honest, I don't want to sound pedantic, but this gathering demonstrates that in the last 2 or 3 months, what actually we've been doing is physical distancing, not social distancing. In actual fact, today we couldn't be closer from a social point of view. We might be distant physically, but we're very close socially. And of course, we know how strong the Alumni Association is at SAIS. Now, today's panel is devoted to human rights and migration. And we have, in my opinion, 4 stellar speakers to discuss this topic. Before introducing the first speaker, however, allow me to underline 1 or 2 points. As one of the world's leading experts, Ruth Rubio Marin, has rightly pointed out, in spite of the fact that migration has become a structural feature of many Western countries, the last 2 decades have witnessed an almost generalized restrictive turn among these countries of destination, signaling a marked deterioration of migrant status. Now, of course, for anyone approaching migration from a human rights perspective, we must remember that as a matter of well-established international law, states enjoy the right to control the entry, residence, and expulsion of aliens, the only exception being international refugee law. We therefore have to ask ourselves the question of whether states can deny or limit human rights as a way of achieving their immigration asylum policies. Or can we instead say that human rights are linked to personhood, not national citizenship, and therefore the policy options in the immigration domain should be strictly constrained? Of course, personally, I would adhere to the latter. But of course, I'm not one of the speakers today, so without further ado, let me introduce our first panelist. And our first panelist is Anna Hartmann. Anna is the Stephen Muller Professor at SAIS Europe, where she is teaching courses on development policy and development economics. Prior to that, Anna worked for 23 years with the World Bank, including 10 years in senior management positions. She was the World Bank Director of Southeast European countries during the Balkans War and established the program between Romania and the World Bank immediately after the Romanian Revolution. She has also been a senior advisor to the World Bank's managing director. She also regularly holds multi-year assignments on panels established by the boards of banks, such as the Asian and African Development Banks, to investigate complaints of people in developing countries who argue that they have been harmed by projects that have been financed by these institutions. Now today, Anna, who, as I say, will be our first speaker, will address the topic of conflict, migration, and hunger. The floor is yours, Anna.
Well, thank you very much, Justin, for this introduction. Well, as it is my profession, I will approach this topic from the point of view of developing countries. And I picked the subject of hunger as a universal human right and its relationship to migration. And I will lead you through a nexus of hunger, conflict, climate change, and migration. Now, as I said, freedom of hunger is a universal human right embedded in the 1948 Universal Declaration and in the International Covenant on Economic and Social Rights. And not surprisingly, zero hunger objective is also an objective under the Sustainable Development Goals, which the world community has adopted to reach by 2030. So the question today is, how are we doing on reducing hunger worldwide to zero? And the short answer is very badly. Among the SDG objectives, that's one of the worst performing objectives. If we look at the evolution of hunger, undernutrition in the world, we've seen a significant decline between 2005 and up to 2014 in all regions. Ever since then, we see stagnation. And as the world community is increasing, we see an increasing number of people suffering from hunger today. In fact, we're seeing 820 million people today, and a share of about 11% of the population being undernourished, which means being hungry. Now, the question is why? When we look at the regional distribution, we essentially see stagnation in all regions. In Asia and Latin America, we saw a rapid decline between 2005 and 2014, stagnation since then. Since in Africa, and that's very disconcerting, we see an increase of hunger, and particularly in West Africa and in Southern Africa, where today more people are hungry, a larger percentage share of the people than were in 2005. Now there is this, what can we say about this development? We see a very clear correlation between countries in conflict and people being hungry. Of the 820 million people today being hungry, 510 million live in conflict-prone countries. And of the 180 million children being stunted, 130 live in conflict countries. So there's a very close linkage between hunger and countries in conflict. There's also a strong correlation between hunger and countries being prone to climate change. There's countries which have been subject to significant climate deterioration see a significant increase in hunger and malnutrition. Now, what is the linkage here to migration? In principle, what we see is, I talked to you, I said there's a nexus. I want to walk you through a nexus of hunger, conflict, climate, and migration. While it's clearly understood why countries in conflict lead to more hunger, because, you know, in countries in conflict, you cannot work agricultural production systems anymore, assets are destroyed, livelihoods are destroyed, makes a lot of sense. People fall hungry. Not so clear is whether actually hunger in itself causes conflict. And then the answer is, it's a very strong contributing factor. In itself, it does not necessarily lead to conflict, but undernutrition combined with climate change impact tends to, combined with ethnic conflict, which comes out under strained situation, often leads to conflict and then leads to hunger. We also know that there's a very close linkage between migration and conflict. So what we see actually, the research which has been done is that countries which suffer from undernutrition, that's a tremendous push factor towards conflict and then towards migration, typically aggravated by other issues like general livelihood issues, poverty, inequalities. Now, what can be done about that? There are two issues. One, hunger, being a universal right, the right to be free of hunger, has to be addressed. The agenda is disconcerting. We have not made significant progress in agricultural productivity or climate adaptation agriculture in developing countries. Cereals yields in Africa have essentially stagnated over the last 20 years. There's not been such a significant breakthrough in the Green Revolution. So the agenda is research in climate-intensive, climate adaptive agriculture can make a significant contribution to reduction of hunger. That being said, it's not enough, because if we go into more climate adaptive, high yielding agriculture production, we will release labor from agriculture. 60% of labor in agriculture in Africa works in agriculture. If we now improve technology and go more into technology intensive agriculture, labor will be released. These people need jobs. These people need jobs to earn their income and to buy the food. So there's an agenda, dual agenda: improve agricultural productivity, improve livelihoods, improve income. Only the combination of these two actually will improve welfare and reduce migration. Now, today in the COVID-19 agenda, the prospects are not good. We are all looking towards an agenda where we will see a significant decline of GDP. Now, fortunately, and I hope they are right, the IMF just released the data for Africa. And unlike for the US and unlike for Europe, the projected declines are much lower. We are only actually supposedly, and I hope they're right, looking at a projected decline of minus 1.6% in 2020, with some countries having higher. So hopefully in Africa, the hit will not be so significant. But that being said, with a little progress or no progress made on the hunger agenda, the push for migration, there's a huge agenda out there on improving agricultural productivity in a climate adaptive fashion and creating improved livelihood for those people, in particular in Africa, but also in other parts of the world. Thank you.
Thank you very much, Anna. Thank you. You've kept to the time allotted. That's great. And I'm sure there'll be plenty of questions during the Q&A. At this point, let me introduce our second speaker, Susanna Mancini, who is the Chair of Comparative Constitutional Law at the University of Bologna. And she's also an Adjunct Professor of International Law at SAIS Europe, where she teaches a very interesting course in multiculturalism and women's rights. She's presently a visiting professor at the Columbia Law School and Vice President of the International Association of Constitutional Law. Her work includes anti-discrimination law, law and religion, and reproductive rights. Her latest publications include The Conscience Wars, Rethinking the Balance Between Religion, Identity and Equality, published with Cambridge University Press and co-authored with Michelle Rosenfeld, and a very recent publication that's about to come out with Edward Elgar, Constitutions and Religion. Susanna has decided to address migration and reproductive rights in this panel. The floor is yours, Susanna.
Thank you very much, Justin. Thank you for this very generous introduction. So I thought about addressing this issue, which is often not somehow a neglected aspect of the migration crisis. Well, one way to look at this topic is to look at it from this perspective. Migrant women, in effect, deal with the same difficulties as many European and American women do in access to sexual and reproductive health. But clearly, what migrant women face is compounded by the situation of high risk, the situation of vulnerability that they face, which of course makes their difficulties much worse. However, it is true that globally women continue to face all sorts of barriers in accessing sexual and reproductive rights services because of a number of issues that boil down to lack of financial autonomy, gender-based stereotypes, stigma associated with female sexuality, etc. An important factor is growing religious conservatism and fundamentalism around the world that has provoked a dramatic backlash. Think about Turkey, Poland, Russia, the US, where multiple patriarchal factors that hide behind the notions of culture, religion, etc., further impede women's sexual and reproductive rights. So it is important that sexual and reproductive rights are not seen in isolation. They are part of women's human rights, and in effect, the gender-based norms and the structural inequalities that deny women sexual and reproductive rights also deny them other citizenship rights. So yes, a disproportionate number of maternal deaths occur during humanitarian crisis, but the let's say the violation of women's rights in these contexts occur in correlation to pre-existing gender-based inequality and gender-based violence. That being said, there are, of course, specific challenges that are related to migration in this particular field. In effect, very often migrations let's say, occur with minimum warning. So all of a sudden you have mass arrivals in countries that very often are already struggling to provide minimum standards of care to their own citizens. And so it is very difficult for their healthcare system to take on the burden of the new of the newcomers, the refugees, etc. Moreover, often refugee camps are highly unorganized. People are confined for security reasons. They are also confined for legal reasons because of their status. So there is no transportation. And all of this, of course, makes it almost impossible for refugees to, let's say, take advantage of local healthcare systems, and of course makes them more likely to be exploited. Now, of course, the situation of irregular migrants is even worse because they might even fall outside the rights framework that is established for refugees. There are, of course, problems having to do with prejudices and limited awareness of sexual and reproductive rights by healthcare workers that make discrimination worse. There's communication difficulties, there's cultural beliefs, there's pre-existing conditions, etc., etc. You can think of cases like Lebanon, for example, that is hosting like 1.5 million Syrian refugees. Most of them, I think over 70%, are women and children. And a recent really heartbreaking studies found that Syrian women report lack of dignity as the main barrier to their use of healthcare and services in the field of sexual and reproductive rights, mainly in the form of attitudes of the medical personnel, so naming and shaming, in, for example, the lack of gynecological services for adolescent women or unmarried women, and the stigmatization that is related to seeking such services. We can also think of what is going on in Latin America that is experiencing a situation that has no precedent, with like 4.5 million people coming from refugees from Venezuela. Government have responded in some cases, trying to increase education and health services, but these let's say responses have really not been up to the need. To the contrary, this crisis has definitely contributed to an increase of gender-based violence. There's sexual exploitation, prostitution that has become a survival strategy for many women, etc. And it is widely reported that health providers are totally unprepared to handle cases of sexual violence. They have no rape kits, they have no emergency contraception, etc., etc. There are some specific issues that one should tackle when looking at this, at the interrelation between human rights, reproductive rights and migration. issues, for example, having to do with sexual violence in armed conflict. It is now known that it is more dangerous to be a woman than a soldier in an armed conflict, as Major General Patrick Cameron said once. And yes, the UN has declared that systematic rape is a crime against humanities, but the international political will to prosecute this crime is not satisfactory. We've seen how low is the number of people that have been charged and convicted by the two international criminal tribunals for Yugoslavia and Rwanda. And also, more in general, let's say that initiatives, international rescue related initiatives, are very often not up to the task. They are not sensitized to the needs of women who are victims of war. For example, the minimal initial service package for reproductive health in crisis situation does not include abortion services for rape victims. So you see that here resistance are mainly of cultural nature, but they do hamper access to minimum standards of sexual and reproductive rights for women. Another important issue is the fact that worldwide over half of refugees are under the age of 18. And female adolescents are a particularly vulnerable group. Yet the problem is that children are wrongly considered as gender neutral, despite the fact that violence against women starts by and large before the age of 18. Think of FGM, forced marriages, rape, malnutrition, where girls get fed worse than boys, etc. Now, one of the problems here is that laws on violence against women have always been enacted taking into account, let's say, the patriarchal oppression that women have experienced throughout history. But this does not apply to laws that protect children. So the problem starts already at the, let's say, law framework and policy framework. And then, of course, implementation follows. And there's a lot also to be said about social taboos concerning young women's sexuality, which, of course, is still very strong also in America and Europe, but this plays an important role in the lack of protection and in the lack of action to protect young female migrants. There is an issue of having to do with child marriage, which of course is a tradition that has a lot to do with gender inequality to begin with, but in the conditions of refugee camps, this is exacerbated by, for example, the insecure situation. Some parents might think that they marry off their daughter in order to protect her. Some parents lessen their financial burden by marrying a child daughter. So in this setting, it is well known that some religious leaders also, let's say, permit child marriage without a formal registration, which is, of course, leaves these children, these child brides, without any legal protection. The last thing that I want to address is that, at least in Europe, we do have a convention, the Istanbul Convention, that is the only comprehensive instrument on violence against women and girls that could really do a lot of good, because this convention looks at violence against women from the perspective of its being structural and systemic. It looks at violence against women through a gender lenses. So violence against women occurs because of a very long history of patriarchy in which women have been dominated in virtually all spheres of life, the private sphere and the economic, political, and social sphere. The Istanbul Convention treats all women alike, regardless, of course, of their status as migrants, and it actually mandates that states should protect the right of migrant and refugee women by, let's say, neutralizing limitations imposed on the rights of those women through various other laws, like laws on citizenship and migration, for example. Moreover, the convention has a number of articles that specifically target migrant and refugee women, but it is not surprising that these articles are the ones that have received most, let's say, reservations. Most reservations by states have been put on those articles, which is particularly bad because it ends up by, let's say, by segregating women into those who are worthy and those who are unworthy of protection, depending on their legal status. The convention is under attack everywhere. It is accused of, especially in Central and Eastern Europe, it is accused of adhering to gender ideology. I don't know exactly how to define that. There is no such thing, but it is claimed that it's been adopted to undermine traditional family values. The Constitutional Court of Bulgaria has declared it unconstitutional because it is contrary to the different roles that the Constitution assigns to men and women. So women are mothers and wives. This whole thing has created a panic. The convention is portrayed as an affront to tradition, but in effect, it is really an affront to patriarchy. So taking into account this combination of misogyny and racism that is increasingly displayed by populist political actors in Europe, and not only in Europe, it is absolutely critical that this convention is ratified and implemented both at the European Union as well as the national level. Thank you.
Susanna, thank you very much. And again, I've got a sneaky feeling there's going to be a lot of questions on this topic during the Q&A. Now I'm going to hand over to Jackie Mazza, and I think in many ways Jackie is kind of the quintessential SAIS alumna. She graduated in the Bologna class of 1983. Then she obtained her PhD from SAIS in 1998. And then evidently she couldn't break away from the school. So she's been teaching a very popular course in labor markets in developing countries at the Bologna Center since 2016, and has been teaching at SAIS in DC in the Latin American studies for the last 15 years. Prior to joining SAIS full-time, Jackie was principal labor market specialist at the Inter-American Development Bank. Professor Mazza has written books and articles on labor markets, migration, and US foreign policy towards Latin America. And most recently, I know Jackie is writing on the US-Mexico border and Chinese migration to Latin America. This afternoon, Jackie will talk about migration and the legal right to work. And I think she has some slides that she's going to put up as well.
Yes, I'm trying to put them up on the slide. I think they're there. Thank you very much, Justin. And it is true that I am the poster child for once SAIS gets you in their grip, you may never leave. I warn my students when I start out each class. It's really a pleasure to be with you all, even if it is virtually. And like my colleagues, my topic technically doesn't appear to fit on a panel of human rights and migration. But I'd like to stimulate a bit of discussion about work and human rights today, and whether the access to work or the right to work has really become, in today's world, an essential gateway for enabling migrants to access many of their other fundamental rights. And whether we are seeing in some countries, particularly within the United States and in some countries in Europe, the denial of the right to work has become really a backdoor to denying other more fundamental rights to migrants. And we're seeing that even more in COVID-19, which we're going to be discussing, I'm sure. So I'm trying to do this for you by presenting three what I would call mega cases of receiving countries of migrants: Uganda, South Sudanese, and the DRC in particular, Colombia, and the United States. I'll start first with Uganda, because Uganda is really remarkable as one of the most open countries in the world, particularly given its conditions in terms of permitting migrants and refugees the right to work. What I am going to present, though, in each of my three cases is whether the rights to work framework fits, whether it works for migrants and whether it matters for migrants. Let's just talk a little bit about numbers in Uganda. There are 1.4 million refugees in Uganda. That is the highest number in all of Africa. They are both in the capital city of Kampala and in settlement camps run by UN agencies, major donors, international NGOs. As I mentioned, you walk across the border to Uganda and you immediately have the right to work and the right to free movement. That is, no bureaucratic process, no registration, at least to access your ability to enter the labor market. But we have some key limitations on that right to work. And that is, we are talking about a highly rural, highly informal, low-income economy. That is an economy with very poor absorptive capacity for these refugees. We are, in a labor market sense, in a kind of low productivity work trap in Uganda. And I have a picture here. I was remarkably in Uganda at the refugee settlements, both in the south and the north, literally in mid-March, just before the COVID-19 closed the whole world. And here you're going to see, in essence, this is in a settlement camp in South Uganda, where refugees are given a small piece of land and daily food aid. You can see this small piece of land that one builds their home on. That is very poor quality agricultural land, and is becoming smaller and smaller, the plots that can be given to more and more refugees. But what is one of the ironies, perhaps, or problems with humanitarian aid in these refugee settlements? And that is the daily flying and trucking in of food aid for this massive group of refugees has become a major distortion in the local agricultural markets. It addresses the issues of hunger that my colleague Arna had pointed out, but at the same time, it prevents the development of a local rural market in agriculture, in essence, making it more difficult for refugees to make a living with their plots of land. I'm going to fast forward us to Colombia. Here in Colombia, I have a picture of migrants moving across one of the many bridges from Venezuela into Colombia. You can see visually the free flow of migrants into Colombia. Colombia has currently 1.6 million Venezuelan migrants that have been flowing in since 2015. Colombia is the largest recipient of migrants in Latin America from Venezuela. But we also have to remember Colombia has another 1 million Colombians internally displaced from their 40-year civil war. In terms of the right to work, essentially, anyone is allowed access into Colombia. They have a program of temporary work permits called PEP in Spanish. They are allowed, with some caveats, children are allowed access to school and basic healthcare. But as my colleague Susanna mentioned, the healthcare system is currently overwhelmed, and there are major problems with access of Venezuelan migrants to healthcare. But if we turn back to the work situation, even we can look at the most recent numbers of the number of temporary work permits at 676,000 as of January of this year. But that's 676,000 permits issued all for the entire period. There is expiration, there is bureaucratic delays. That's not more than 500,000 people with temporary work permits. And look at that vis-a-vis the number of Venezuelan migrants. That is, it is covering an increasingly smaller percentage of the Venezuelan migrants who are coming in. When we look at labor force surveys, the most recent one shows that more than 90% of the Venezuelans, whether they have a work permit or not to work in the formal sector, end up in precarious informal sector jobs, but despite being on average more educated than Colombians. And so again, I raise the question of, does it matter the condition of temporary work permits when the migration crisis, in essence, is overwhelming Latin American economies? The latest numbers are 5.3 million Venezuelans who have left, and 8 out of 10 of them go to Latin American countries. What does that mean? That means that labor markets in all of those countries are overwhelmed in integrating Venezuelans into the economy. Colombia has a mixed record on temporary work permits, but it's better than Peru, Chile, and Ecuador, who are the next largest recipients of Venezuelan migrants. Fast forward us to the new COVID-19 world, where Colombia has closed the formal border crossings between Venezuela and Colombia, and the country is on a pretty strict lockdown. What has that meant when the Venezuelans are principally working in precarious day labor in Colombia? It's meant that migrants are rapidly losing their access to the cash that they had in informal work, since they were in agriculture and in local services. We have had evictions from temporary shelters because of COVID-19. Venezuelans are no longer able to pay their rent, also evicted onto the street. We even have the bizarre phenomenon of some of them walking back to Venezuela, which has a collapsed healthcare system and massive food shortages, because at least in Venezuela, they would be able to live in housing with relatives. Fast forward again to the United States, which has the most restrictive policies on the access of migrants to work, yet ironically, the greatest absorptive capacity economically, and quite honestly, an economic need for particularly low-skilled migrant labor. The numbers currently on unauthorized immigrants to the United States are 11.3 million. You can see by my map, they're largely concentrated in the major cities on the East and West Coast. The studies on the economic impact of those migrants have shown that the US economy is 11% larger than it would have been had it not had these 11 million undocumented immigrants. They play a key role in the services sector in the United States. We know that hotel sector, restaurant sector, agricultural harvesting, and meatpacking. Again, sectors that are particularly affected by COVID-19. If we look at economic studies, there is literally no evidence that particularly low-skilled migrants are taking American jobs. We see only what would a difference in wage effects, that is slightly lower wages, but just for the ages of 15 to 17 in the United States. We do have some competition, particularly in the high-tech sector, but these are high-skilled visas. That is, those principally Chinese and Indians who have gotten high-skilled visas. They are, in certain cases, replacing US workers, but again, they're doing that on a legal basis because the Chinese and Indian workers are less skilled, but less costly than the US equivalent. Let's turn to the work authorization issue in the United States. Almost all the SAIS community knows about the challenges of getting that green card, that permanent legal residence in the United States, both which allows you to work freely. Both the difficulties in bureaucracy and the long length of time it takes to get that green card. The United States has very limited temporary seasonal agricultural programs, way too small for the demand that exists in the American agricultural sector. Again, I mentioned the high-skilled visas, which are limited right now in the United States. But two other areas that have been subject to cutbacks, that is, the Trump administration has made a dramatic cut in the number of allowed refugee admissions into the United States from 110,000 under Obama to 17,000 in 2019. At least that was the projection before the March 2020 halt by the Trump administration because of 19. That is, there are no refugees now being processed for entry into the United States, despite the conditions around the world. The other area that I'd like to point out, which has happened as well in Europe, which is the dramatic restricting of the right to enter the United States and apply for political asylum, which is protected both by international and US domestic law. This has, in the newspapers, you see this a lot in this concentration of control and border security. But I want to use some facts in the SAIS context, and that is well before Trump was elected, the border crossings between the United States and Mexico had been falling from their height in 1998. And today, border crossings is not the principal source of the 11 million undocumented workers. That is actually visa overstayers. What has happened at the US border is both a drop in the volume of numbers and a change in the composition. That is proportionately fewer Mexicans, increasingly more Central Americans, and more migrants traveling in family groups, and that is women and children. That change is really driven by the security crisis in Central America. Central America, just in the last 5 years, has become the most violent region of the world that is measured in terms of number of homicides per capita. But what has happened in the rights framework, that is, the Trump administration has progressively removed the international and domestically provided right to apply for political asylum in the United States. They started that first in 2018 by cutting the staff that receive these asylum petitions at the border. Then they limited the number of claims they would take each day, and moved on most recently to what anyone would argue are coercive agreements with Mexico and Guatemala to require migrants to first apply in Mexico or Guatemala for asylum before they apply in the United States. And this is the so-called stay in Mexico type of agreement. We fast forward again to March 2020, in which the Trump administration argued or imposed what they called a total border shutdown. But these border shutdown has an immigration twist. That is, the border is shut down only to those who want to request political asylum in the United States, and only to those who don't have proper work documentation to come into the United States. That is, it's not like the border shutdown that's happening in many other countries and even in Latin America. That is, no one is allowed to cross the border, even if they are citizens or legal permanent residents, because of the contagion effect of COVID-19. In the United States case, we're going to see that we're really talking about a politicized border shutdown in terms of immigration law. I just want to end with the Trump administration's move to actually remove the legal right to work for migrants once they've gotten it, or for those who are waiting, and that is waiting patiently in line abroad to get that legal documentation. What we have, and I'm just going to briefly mention the numbers because the numbers are big. The Trump administration is attempting to remove temporary protective status for select countries. I've put those countries up on the screen, but essentially this has been blocked temporarily by the courts. But if the Trump administration is to have its way, 500,000 immigrants who have legal status to work would be immediately undocumented in the United States. The Dreamers are another particular group. Those are immigrants brought across the US border or into the country before the age of 16. Right now, 800,000 have received security checks and are legally allowed to work in the United States, the Trump administration also wants them to be on, to reverse the DACA and make them as well deportable under US law. There are a number of other attempts to make it harder, to make it easier for the Trump administration to remove your green card once you've gotten them. And right now, just last week, they have suspended the visa process for those who are waiting abroad to get their green cards. That is, those who have, in essence, played by the rules. There is a 60-day suspension, and that affects more than 350,000 people waiting for their visas because they have been accepted in the green card program. So I'm going to stop there and just put out 2 points for discussion that really fit quite well, actually, with my colleagues' points. And that is whether we're really seeing a change in migration patterns, that when we have large-scale migration crisis of a prolonged period, that the inability to incorporate employment options into our migration frameworks, that is the need to work to survive, essentially is now overwhelming and prolonging humanitarian crisis that we see around the world. And second, the issue of work authorization, relegating it, as Justin talked about, to solely a domestic matter, that is solely to internal law, without either international protections or even international condemnation, has been for the United States and key countries in Europe, such as Italy and Hungary, a major route to undermine internationally recognized rights and subject migrants to unlawful and highly discriminatory treatment that also violates domestic laws. And I'll leave those questions for us. I know we'll have a great discussion with my SAIS colleagues. Thank you.
Jackie, thank you very much. Now, last speaker is Sara Pennicino, who is an associate professor of comparative public law at the University of Padua and adjunct professor at SAIS, where she teaches a very popular course in international human rights. And she's also an affiliated scholar at the Center for Constitutional Studies and Democratic Development, and has helped to develop various projects at the CCSDD. Professor Pennicino's research areas include electoral management in transitional and post-conflict countries, bans on political parties, and constitutional eternity clauses. Sara works with the Center of Excellence for Stability Police Units, COESPU, training Italian and third country members of security forces with specific regard to human rights and policing, security and elections-related violence, and humanitarian law. And Sara's topic this afternoon is migrants' human rights in the face of COVID-19, an Italian perspective. The floor's yours, Sara.
Thank you for the very kind introduction. I'm actually going to pick up where Jacqueline left. As you were mentioning, Italy is one of the examples of a country that has been undermining over the past 5 to 10 years the rights of migrants and asylum seekers that were trying to land on the shores of the Republic, trying to find a better life than the one they were living back home. And I thought that I would like to support my idea that the way COVID-19 is going to impact the legal status and the legal protection in general of migrants in Italy is one that we will see on the long run. It's better to act well in advance, I think, in trying to avoid that practices that at this point might be enacted due to the emergency situation may actually consolidate and become the common rule to be applied in the future. In order to illustrate this idea of mine, I'm going to bring actually 3 examples. Now, before I start, I'd also like to despite the fact that I totally agree with what Rubio Marin, the author that Justin was quoting at the beginning, her comment on the fact that recently there has been an attack on international human rights and specifically legal protections at an international level for migrants and asylum seekers. I do feel that thanks to the, let's say, approval of the Global Compact in the past 18 months, and thanks to the fact that many countries had pledged to implement the Global Compact in order to really embrace principles of solidarity and sharing the burden of protecting people that are the victims of the conflicts that were caused, as Arntraud was saying at the beginning, by hunger, by famine, by, again, war and other factors. But the idea that there is a burden that needs to be shared by many countries at a global level had somehow found his way through at a time where the political debate seems to be quite hostile to these ideas. So despite the 10 years perspective, the last 18 months actually had made me a little more optimistic. Unfortunately, COVID impacted this environment at a time where we were hoping for a very strong turn in these policies. And the way COVID is going to impact legal systems and legal protections and the relationship between national legal system and international standards, I think might have some importance on the long run. So let's look at the examples. Italy has been quite relevant on the news cycle with regard to a policy that has been very negatively commented, and rightly so, which is that of the closed ports. In the Mediterranean Sea, it is now very, very well known that some countries will declare their ports not safe, and thus avoiding to guarantee disembarkation for people that are rescued in the middle of the Mediterranean by NGOs boats or other ships, and that are, again, trying to land on European shores. Closed ports is not, of course, a policy or a decision that is exclusive of Italy. Now it has been adopted elsewhere, and it is something that it is foreseen by the Hamburg Convention. But yet again, it was foreseen for very specific cases and under very specific conditions. And it has been pointed to the fact that Italy has very often resorted to this legal instrument in a very unsatisfactory way. However, again, this is a good example of how COVID, building on an already unsatisfactory legal regime and on an already unsatisfactory level of protection of migrants' rights, COVID will exacerbate this situation. Very recently, the Minister of Interior has declared the ports of Italy unsafe. Thus, Italy is denying disembarkation to refugees that are rescued at sea. And at this point, these people are being left on a quarantine on a ferry boat, which is left in front of Palermo, which is a Sicilian city on the Tyrrhenian Sea, thus not on the shores facing, actually facing Libya and Africa more in general. Migrants that are on this boat are supposedly being taken care of under all the conditions that are provided for in all the regional human rights convention, as the European Convention on Human Rights, as the international ones, Geneva Conventions, and they are granted all the sanitary and healthcare assistance that is foreseen in these situations. However, it is very difficult for any third external neutral observer to access this ferry in order to double check what the actual conduct of those that are basically detaining the asylum seekers and the migrants on the boat. So this is again an exacerbation of a problem that was already there before COVID. But at this point, because of the emergency situation, the declaration of ports as unsafe places and thus closing, the policy of closing ports is again more and more referred to and is stronger in the way it is argued for. It should be noted, in fact, that there has been recently a big step forward in declaring unacceptable and illegal certain practices that were typical of the Italian institutions when it came to assessing the relationship between national legislation and international law, with specific regard again to the possibility of denying disembarkation of migrants on the territory of the Republic. Very recently, the Cassation Court of Italy has declared illegal the understanding of the law which implies that rescuing migrants in the sea may satisfy the idea of the obligation of rescuing, according to the Convention on Search and Rescue. The actual idea of rescuing people, according to the court, implies bringing those people to a safe place, meaning a place where they can be taken care of appropriately and they can be granted access to the possibility of starting the application process for seeking the recognition of the status of refugee, or at least to, again, filing the application. Unfortunately, as we can see now, that very important decision is, again, being questioned by this situation of emergency that seems to rationally justify the exceptional understanding and the exceptional undermining of the protection of international customary law that in the Italian constitution is actually provided for the effect under Article 10. In other words, at this point, a rule that had been tackled appropriately, finally, by one of the top courts of the Italian judiciary system is again being brought back in the praxis, and the risk is that on the long run, the policy of closed ports will be kind of reinstated as a praxis. This is not, we're not sure that this is going to happen, and it should be stressed that the attitude of the Italian government under the present circumstances has been definitely more, in practical terms, more accommodating and has shown more humanity than in the past. It's not been as aggressive, and the idea of closing ports has not been portrayed as a political type of decision with having political consequences. However, on a factual basis, this is the policy that has been adopted with a ministerial decree. So this is what the law says at this point. What does the European Union say? Is the European Union saying anything? We know that the European Union has a whole series of directives regarding the rules on the processes for applying for the status of refugee, and it has a whole series of rules regarding the conditions under which those seeking for this recognition should be guaranteed. Well, the European Union, for as far as we know, up until now, has only issued a communication from the Commission to the Parliament, the European Parliament, and where it gave very general indications on how member states should approach asylum seekers' rights and migrants' rights under the current condition. The only real criteria that they are referring to are the usual general principles of European Union law, which are proportionality and reasonableness. And of course, the necessity idea is also there in the background. However, having said that, member states are basically at this point left quite free in deciding how to change their regular legislation and policy in the face of COVID-19. Second example. The second example regards not really those that are placed at the borders, which are usually, that is usually the location where human rights of asylum seekers and migrants are violated first, but it regards inside the territory. Those that actually accessed the country, that entered the country and that are now present in the territory, which is a good example that can show how COVID-19 is basically exacerbating very common practices that were already present in Italy. One is very close to what Jackie was discussing regarding the undocumented workers in the US. It has now been proven by the fact that vegetables are not being picked, fruit is not being picked, and the very production chain with regard to food in Italy is suffering because of the lack of workers in the fields doing the job that they have been doing for all this time and that now is impossible to be done because of the COVID-19 restrictions. Now, interesting enough, the reaction of the Italian government is that of saying, well, we will grant documents to those undocumented workers that will go and work in the field. It's not going to be 600,000, all 600,000 of them. It's just going to be those that we really need to go and work in the field, which means that the permit will be coupled with the working contract, with the actual contract that is signed between the worker and the employer. The problem here is that if this is the case, we may end up with a situation which is worse than the one we had before. These people will be basically put under constant threat of accepting whatever condition, whatever working conditions and whatever abuse just to have the renewal of the contract. And this is, again, another good example of how COVID-19 could actually badly impact on the long run the way the Italian system already very badly works. Just to confirm what I'm saying, we were already very badly performing according to the Council of Europe Greta mechanism, which is the mechanism that provides for the monitoring of the implementation of the European Convention Against Trafficking of Human Beings. Our interagency and national referral mechanism is not working appropriately. It is not clear when it will actually be set up, when it will actually become operative. It is in the plans, but it's still not there. And in this situation, even if it's an emergency, there is, again, in this case too, a total lack of third monitoring mechanisms, of neutral mechanisms that would allow us to see whether this is working or not. Third example, and I will close, is that of the confused allocation of competencies with regard to migrants and migration in Italy. Italy has a decentralized system which provides, the constitution foresees a state level, and then a regional level, and then of course we have municipalities. Now, interestingly enough, migration per se, the rules about the access to the republic, those are established by the national level, that is one of the permanent competencies of a national government. However, a lot of rights, especially social rights, are guaranteed under the framework of regional laws. And more specifically, social assistance and welfare assistance, everything that has to do with the livelihood and with the well-being of people that are part of a community is actually in the competence at an implementing level of mayors. So here comes the example. Now we're all in lockdown, we're all quarantined at home. Some people are not receiving a salary and they are in shortage of food. Thus, mayors and municipalities in general are supposed to reach out to this family that are living these very, very precarious conditions and give them either food or certificates on the basis of which they can go get food at the shops, some sort of support. However, because of the 2019 security law passed in Italy, undocumented migrants and illegal migrants are not supposed to be registered by municipalities. These people that might be homeless and that might simply be out of the radar of any type of let's say, of statistics, together with those that don't have a permanent permit, but have a temporary one, these people will not access to this type of support. They will be left out because the approach is left to the discretion of local municipalities that very often apply the doctrine of prima gli italiani, which again was placed before, but might become the rule in the future because of COVID-19.
Okay, thank you, Sara. Great. Now, we have some questions coming through. By the way, I should have mentioned this earlier. If you want to ask questions, please send it through the Q&A and not through the chat. You can use the chat to say hello to speakers, obviously, but the questions should go through the Q&A. Anna, I don't know whether you can also see the question that has been put to you.
Yes, I saw that on agricultural production not being able to be shipped off because of supply chain interruptions and whether that could be used as humanitarian aid.
Yes.
And I must say, the issues I addressed in terms of increasing hunger and its possible cause for migration and conflict is a systemic issue, which has to be addressed with systemic responses. We use humanitarian aid in terms of immediate famine, when there's massive hunger because of immediate conflict or because of a migration settlement. There are grave concerns when we use humanitarian aids because they typically, particularly agricultural products, they tend to disrupt markets and they're very difficult actually to get to the community. Jackie alluded to it. Agriculture, humanitarian aid, food aid can do a lot of damage to agricultural production systems. We try not to do that, but very often they do. Food aid is used to alleviate immediate emergencies. It's not a good instrument to address a systemic issue like, increasing low productivity and hunger. So the answer is, in principle, could be done, but it would be at a tremendously high cost. It would probably not reach the recipients because reaching these people is very difficult, and it might even do some damage. So I would have to look into more depth. It could have been done local in some particular cases, but it's certainly not a good instrument to alleviating the hunger situation. And it could even aggravate it because it could, on the places where it's being delivered, destroy agricultural production systems. So one has to be very, very careful importing food aid to actually alleviate hunger, or use that only in the emergency situation. And given that logistical challenges to even get it to the right places, it's unlikely to be successful.
Okay, thank you, Anna. Jackie, I think we have a question for you from Camilla. The question is, could you also include some views if migrants have an anticipation that they have a legal right to work wherever they want?
Thank you very much for that question. I think we have to go back to our sort of economics basics, that is supply and demand, and in whether or not there is a legal right to work. Essentially, what happens for migrants is they are in any economy relegated to certain sectors which have the demand, whether it's a legal authorization or not. That is, the more there is a legal authorization to work, the more migrants' skills and profiles can be linked to an actual labor market. It is very rare that is possible. That is, in most cases, we are talking about, at best, skills downgrading for migrants when they move forward. I just want to put the case. So if we take the case of Uganda, where there is the legal right to work, we have the case of women coming with midwife skills. We have doctors from South Sudan or doctors from the Congo. Do they anticipate that because they have the legal right to work, they will work in their sector of skill? They do not. They, in fact, there are other barriers to them being able to practice their skill level, even with the legal right to work. So it, in essence, the forces of demand and supply have made the issue of the legal right to work insufficient in order to move through an economy.
Okay, thank you, Jackie. Then we have a question from Vote, Van Eilen. I hope I'm pronouncing his name correctly, class of 2015. And Vote says, I work for a team that monitors the EU Trust Fund in the SLC region. I have a question for Professor Pennicino, but if others want to also intervene, how will the economic downturn and COVID-19 affect the EU's approach towards irregular migration and the protection of human rights, especially across the central Mediterranean route, beyond the European Union and the International Organization for Migration's joint initiative?
Well, if I'm gonna start just because it was mentioned in the question. I think my personal take on this question is that the approach, the externalization strategy, is going to worsen. This is my understanding of where the EU combined policy is going. As for what my perspective is, if you look at Italy, that seems to be the most consistent way of where we're headed. The idea, well, this all humanitarian corridor obsession, this is one of the first evidences that this is the actual route that we want to go down. But more than that, if you look at the development of the combined policies between Italy and Niger, and the type of investment that has been done there and trying in training and in preparing the externalization of the management of the whole flux of migrants moving north. In terms of investing in human rights protection and investing in guaranteeing the protection of basic standards in human rights, I think that if it's going to happen, it's going to be through the monitoring of the procedures in the context of the externalization policy. So if I were to point my finger at a place that one may be looking at in thinking of the trust fund and thinking of the investment that will be done, I would be checking on external action services that are directed to training and democratic assistance and legal assistance of countries that might be part of the scheme of the externalization in the management of migration in the European Union.
Okay, thank you, Sara. Okay, I have a question from Mr. Schlein, who I think is the father of our regional councillor, Ellie Schlein, and former European Member of Parliament. And the question is still for you, Sara. The European Parliament a few years ago voted to modify the Dublin Agreement to improve the distribution of refugees throughout the EU. Unfortunately, the Council chose to ignore the vote. Do you see any possibility of the COVID-19 crisis moving towards an improvement in this area, or possibly the opposite? In part, you've addressed this, but if you want to add something.
Well, for example, this is a typical example. Those that are supposed, migrants are supposed to be moved around Europe because of the Dublin transfers, as established by the so-called Dublinans or Dubliners, depending on the language that you opt for. For Italians would be Dublinanti. Those that need to be transferred, those are stalled. Nobody can move. So up to this point, what I see is actually a very bad sign of the fact that the system will be more and more rigid. I don't think that COVID will positively impact the reform on the Dublin on the Dublin Agreement. And again, even in practice, now leave alone the whole big legislative reform process that was being undertaken at a European Union level, but looking at from my side, from my expertise, which is more that of the monitoring and of the actual monitoring of the implementation of international norms, I think that COVID-19 will have a negative impact on the flexibilization of Dublin laws and Dublin rules. Despite the Malta Agreement, which made us all thought that we were doing well with.
Do any of the other panelists want to add anything?
I'd like to,
Jackie.
in essence, complement this in the same question in the US context. That is, will COVID-19 restrictions, in essence, improve the conditions or laws around migration? And I think we can look again at these areas where migrants are being affected in their by losing work, their precarious work that it is. Do they have access to services? Do they can migrant labor be reemployed? And Sara really used this interesting case in Italy, because we have the same issue in the United States. That is, we have resident agricultural labor, which could be employed in the fallow fields once it is safe. But there are not efforts to, in essence, use positive strategies, that is, to employ immigrant labor in a positive way to address COVID-19. What we have is the opposite, that is the using of COVID-19 to pursue an anti-immigrant agenda, which is what's happening in the United States. That is, rather than focusing attention on what industries can grow, the access to the transport industry, essentially the Trump administration, and they said it out loud, are using COVID-19 to enact things they have wanted to pass before, but did not have judicial muster. That is, and we have, for example, in the United States, we have the courts saying, we can't, in the case of a national emergency, overturn some of these anti-immigrant actions by the Trump administration, at least on the grounds of COVID-19, whereas previously they had that right.
Okay, thank you, Jackie. Susanna, there's a question for you. What would you consider being the main obstacles to provide protection for girls, boys, and women in refugee camps against sexual violations? And what has worked to provide protection in such refugee camps, and why? This is a question by Camille again. Audio.
Thank you. Sorry about that.
All right,
thank you, Camilla, and thank you, Justin. Well, one of the issues that has been remarked that really pops up in all of the studies that have been done in this field is that there is a desperate need to educate and train providers, healthcare providers, through a feminist lenses, to teach them to approach these issues, taking into account that gender is a fundamental category here. So we've seen that this really doesn't work. I think the examples that I mentioned before clearly show that there's a fundamental problem there. Then specifically with children, like I said before, children are not asexual. So this is particularly important, that we do not treat children as a, let's say, abstract category, but we focus on the specific issues that children of different sexes suffer in these particularly vulnerable situations. But the problem is that there is a massive work to be done to reduce the idea that children and women are buyable, sellable, that female sexuality has a different worth than male sexuality. These are all problems that are, of course, related to this issue. But it's like when we discuss rape during war times or during conflict, the problem is that the explosion of violence against women doesn't come out of nothing. It comes from deeply ingrained hierarchies of power, structures of inequality that women have suffered throughout history everywhere in the world. So unfortunately, however, there is this increased antipathy and hostility towards human rights. Philip Alston has written a wonderful article putting really, every piece of the puzzle into the right place. Human rights are increasingly associated by majorities to liberal minorities. The UN, well, there's Trump that declared to the New York Times at some point that we get nothing out of the UN. They don't respect us. They don't do what we want, and yet we have to fund them disproportionately. I mean, this kind of hostility against human rights, which takes with its shape really as a xenophobic, misogynistic, nationalistic, anti-LGBT rights, etc. Mood is the one we should really, I think, focus on.
Great. Okay, we've got about 5 minutes left. So there's a question for you, Jackie. Live Loet. The use of COVID-19 in a positive way, I think it was what you were saying earlier. Are there any examples anywhere in the world?
Thank you, Liva. Liva is from the class of '83, so I hope to be seeing you all. I appreciate that. I wish I could be positive. I think what you're seeing is positive examples on the non-state level. I think if we talk here in the United States, we really are talking about initiatives for the support of healthcare workers, for the food and care of migrants. We have in the United States NGOs who are stepping in to look at the migrant conditions in detention cells and initiating court cases in the United States. So I think we are seeing that the COVID-19 crisis that affects equally migrants and citizens has motivated some citizens to see the situation differently.
Great. I think Susanna wanted to add something very quickly, and then we will wrap up.
No, sure. I just wanted to say that Portugal has granted
migrants as well. Sorry, Susanna.
Sorry. Okay, that Portugal, it provides a really wonderful example of having granted asylum seekers and migrants full citizenship rights during the COVID emergency. So maybe that would be a good. This is one of the good examples. Even in Italy, there are rumors that Italy might decide to legalize illegal migrants, at least to provide healthcare, which is, of course, in everybody's interest.
Anna, and then we will close.
Just a short point from the German perspective. I'm sure we have quite a few German alumni listening into it, but I mean, one debate we had in Germany is when temporary workers could not travel to Germany, primarily from Romania and Bulgaria, to help with the harvest, and the farmers complained that they couldn't plant and they couldn't collect especially the asparagus, and they didn't want to have any Germans because they didn't think the Germans could do it or wanted to do it. Then the issue was tabled, why don't we ask our migrants to actually work? And in Germany, it's actually not allowed to work until you get your permanent recognition as a migrant. That often takes years and they sit around. So at least I felt there was a debate starting now, whether one could change the labor rights or the right to work of people who are in Germany and often wait for years and years not being able to work. And I mean, maybe one could see, and the Germans recognize that there are a lot of jobs in spite of having low employment that right now in the crisis that we simply don't want to do. And maybe we want to be more forthcoming in actually integrating or giving the right to those people who live with us already, but who are waiting there for a long time and cannot be employed.
Great. Okay, I see the shadow of our director appearing on the scene, and I think at this point we need to wrap up. I would like to first and foremost say thank you to everyone out there that we can't see, but that has been following this webinar for the questions. We've had a good Q&A session, and then I really would like to thank my 4 colleagues for what I think has been a really interesting conversation this afternoon. And I would now like to invite you all to our Spritz Aperitivo. You should already have the link. This means changing there you go. I think you can see it on the screen right now. So we have to change rooms. So see you in a few minutes in another virtual room for our spritz aperitivo. Thank you very much. Thank you, all of you who have been following and the speakers. Bye-bye.